For people that don't know, because I'm a little confused about it. Why does the Railroad Commission oversee pipelines here? Because I think of railroads as the competitor to oil pipelines. You know, trucks carry oil, railroads carry oil. Why does the railroad have regulatory authority?
Well, the name will fool you. The Railroad Commission was created by the legislature before 1900, and with the express purpose of regulating railroads, the tariffs for transporting cotton and whatnot. From that, the oil business began in Texas in the early 1900s, and it became obvious that some regulation needed to take place in order to make sure that fields and whatnot were developed in a very orderly manner. Because you've seen pictures of places like the old city of Kilgore in the early days, drilling rig legs interfacing between each other, and you'd get 10 wells on a 3-acre tract, and that's absolute waste. So the legislature enacted a bunch of laws, delegated the authority to enforce them to the Railroad Commission, which involves spacing of wells, the amount of oil or gas that can be taken out of a well to prevent absolute waste, and to make sure that they were properly drilled in case prevented pollution and that sort of thing. So the Railroad Commission name has been there since, before 1900. Every once in a while, somebody wants to change the name because they don't do anything with railroads anymore. But for some reason, that's always been a political football. And there's a bill now this year to change it to the Texas Energy Commission or something like that. Whether it'll pass or not, I don't know. But the name Railroad Commission is misleading.
And when you look at the situation in North Dakota, obviously, it's very clear there was certain parts of the pipeline that were federally controlled, the Army Corps, whereas here it's all private land.
For the most part, yes.
For the most part. And when you look at the private land, they're using eminent domain. Eminent domain is this towering phrase. A lot of people don't understand the complete intricacies, but highways, schools have been built based on eminent domain. What was the rationale given by the state government, the company, to use eminent domain to dig the pipeline through people's homes?
The history of eminent domain, as far as private entities are concerned, goes back to probably, again, the early days of the development of oil and gas. The argument was made that the movement of crude oil or natural gas, particularly for the benefit of the public, a gas for home heating and this and that and one thing and the other, was a public purpose that the state should promote. Secondly, there was also a very distinct problem that if crude or gas was not moved through pipelines, then industrial or economic development would not take place. So the legislature delegated the state's power, which is an inherent power of any government, delegated that to begin with what they called a common carrier pipeline, and specifically for those who were engaged in transporting crude oil from the fields to the refineries or wherever, both to prevent waste, to prevent pollution, and to further economic development to get the oil and gas to market so they could be refined to gasoline and whatnot. So there was underlying that a strong sense of public purpose. And the argument was that that public purpose was stronger than the ownership of private property, and private property to some extent had to yield to that authority. So that's how this puts together. That concept is still there. As you know, this nation is covered by pipelines all over the place. Many of them are regulated under federal law because they go from one state to another state and are then engaged in interstate commerce. State pipelines, we have from, say, West Texas into the Houston area to supply the refineries there with either crude oil or natural gas. Natural gas is also probably the primary fuel for domestic use. It is also a very very high percentage of natural gas goes into electric generating plants, which generate electricity. The crude oil goes into the refineries to become gasoline and many other products. Those are all viewed as the general term public use, which supports the delegation of eminent domain power to private entities. But when the legislature does that, they set up certain standards, and the pipelines have to comply with those standards. If they don't, often someone whose land is proposed to be taken will challenge that and say your use is not a public use. And if the court says you're right, they don't have the power of eminent domain. Now, there are a lot of pipelines carrying whatever that are strictly private. They are for the company's benefit and use. They do not have the power of eminent domain, and it's up to them to negotiate a right-of-way with every single landowner they propose to cross. That's another whole ball game. So they don't get the power from the state.
When you look at the Trans-Pecos pipeline, it's not interstate. It's going to another country, and as far as I could see, it's going to be liquefied and sold to Asia. So, in your view, as a veteran of this industry, is there any legal or rational explanation for this as the public use?
You've asked me a question that I have spent a lot of time working on, and some time trying to get attorneys who are representing some of the people in the condemnation proceedings on that Trans-Pecos. And I've provided them with my own analysis, if you're interested.
I'm very. Drove 6 hours.
What Trans-Pecos did, the pound, and I'm speaking of the entity, they went to the Railroad Commission, who issues pipeline permits. It's on a little form we all talk about called capital T-4. And when a pipeline applies for it, and the commission handles only an intrastate function. When they apply for it, they fill out a form and they say, we are a common carrier, we are a gas utility, or this is a private line. They check a box. Provide a map. Here's where we're going. Here's where we propose to do. The staff may ask a few questions, but in the history of the Railroad Commission, they've never turned one of those permits down. It is, among a lot of people, a rubber stamp, considered a rubber stamp job. And that's the end of it. If they say they're a common carrier, or if they say they're gas utility, they then will walk down the street to the landowners and they say, I have this permit, and the law says I have the power of eminent domain, and I'm going to take your property, but here's my offer. If you don't like it, we'll sue you and we'll go through. And that's what happens. Now, what Trans-Pecos did was get a permit for the segment of the line from Waha, which is up in Pecos County. That's a huge, what they call a hub. Many pipelines come in through there, most interstate. And we're going to take gas from the hub in pretty much a straight line to a point near Presidio on the border. And that's the intrastate portion. And the commission granted them a permit. They proposed to put in a 42-inch line. But what that line does, they're going to go to Presidio, they're going to go under the river and pop up on the other side of the river, which means they are transporting gas to Mexico for resale. So I started digging around, and I had, years back, I had a fair amount to do with the Federal Energy Regulatory Commission and was reasonably familiar with the Natural Gas Act, Federal Natural Gas Act. And I said, something's wrong here. So we start digging around, and about 3-4 months after they got their permit, D4 permit from the Railroad Commission, we find an export permit, which they had to get from a part of the Federal Energy Regulatory Commission to export gas. And that's required by Section 3 of the Natural Gas Act, Federal Act. Okay, I said, what is the impact of that? And they've declared themselves to be a gas utility, which is, we have a utility code that defines gas utility. And in another section of the utility code, it simply says a gas utility has a power of eminent domain. It's a very simple statement, no standards, no nothing, just says you have the power. But the definition of gas utility, the primary definition in the statute, exempts a pipeline transporting, selling, or reselling natural gas in a manner subject to the Natural Gas Act. And they are. Therefore, they're not a gas utility, and therefore they don't have the power of eminent domain. Now, I have gotten that analysis to at least one attorney who has somewhere between 6 and 10 of the condemnation proceedings in Trans-Pecos that it's handling. He had another claim which he had filed with the state court, a plea to jurisdiction, challenging the jurisdiction of the pipeline under various and sundry things, and he had it set for a motion. He liked what he said. Nobody thought about that. He didn't feel like he could modify his motion before the court then without creating a lot of problem, and I agreed with that. He's argued his motion, the constitutionality of a portion of the statute giving that gas utility eminent domain power. It's been heard. We expect he expects a decision from the district court, let's say in January, maybe early February. But he said if we don't prevail on it, I'm going to use this theory next. I've tried it with several other attorneys, and they're pretty much in the same posture. They have gotten so far along their case that they don't feel like they can change their theory right now. But I think it's solid, and I've tried it out on several very, very prominent appellate lawyers who don't do anything but practice before the Supreme Court of Texas, and they have labeled it the silver bullet. So we'll see. The second thing that's going on is there is a challenge to the jurisdiction. There is a challenge to the constitutionality of the delegation of eminent domain to a gas utility on the theory that the legislature didn't give them any standards. It just says you have the power and went home. That one is sitting in the hands of the Fifth Circuit in New Orleans in federal court. It has not been set for hearing yet, but it's been briefed, ready to be heard. Either one, the state case or the federal case, if either one of those prevail, the pipeline obviously will have to appeal. But that's a winner-take-all case, both of them. And, you can sit here and say, well, if either one of them wins, and the Supreme Court, the federal case will go to the Supreme Court of the United States, the state case will go to the Supreme Court of Texas. Either one win, they don't have the power of eminent domain. So they're at risk, but I'm sure they have talked themselves into a position where the risk is very slight.